May it please the court. My name is Janelle Weber, and I'm here on behalf of the appellants, John Ahhand Jr. and Rebecca Hegan. I would like to ask the court to reserve 4 minutes for rebuttal.
Can I ask you a question up front?
Yes.
You can tell I kind of do that only because, I kind of have the issue in this case that I struggle the most with is the timing of the recording of the deed and the declaration being 41 minutes apart. The initial deed out, which made no reference of any easements or any reservations in that regard, followed 41 minutes later in the public records by a declaration attempting to do that. Now, under every real property law that I know, timing of recording of things is critical. People that practice real property, they're very worried when they go to the courthouse. They want to get, if they're trying to do something like this, they want to make sure the declaration will follow the deed, or the deed will have referenced the declaration or the reservation or something like that. None of that happened here.
That's right. Sandra Hippolyte, she recorded the deed first, followed by the original declaration. There is no affidavit in the record that would support the contention that she made a mistake. There is no deposition testimony to explain her intent in making that decision about doing one before the other.
So what do we make of this then?
Well, what we've argued in our initial brief and our reply brief is that you have to look at the black letter law. And under the black letter easement law, when you have one property owner that owns 2 pieces of property or multiple pieces of property, and that property owner intends to create an easement while simultaneously owning them, he cannot do that because the 2 estates, those interests, they merge. And when you have that type of merger, then the purported easement is a nullity and it's void as a matter of law.
So let's say we go with your theory about this easement. We have 2 docks that are on the sound that we're trying to address. One dock is clearly on one piece of property. The other dock could only be accessed by the easement. And if I've understood this correctly, and the dock that you're trying to access or has been accessed by virtue of the lower court ruling doesn't appear to be, I can't match up how the easement connects to that dock.
It doesn't connect.
Okay.
There is nothing in the record that would suggest that it does connect. And this appeal only concerns the dock that's on the Hagelands property. The other dock is on a separate piece of property that's adjoining, and that's not at issue in the count.
Yeah, that's the L-shaped dock, right? That's not at issue.
Not in this appeal.
Okay. It's the T-shaped dock on the other, I call it, it looks like it's got a T-shape,
Yes. So there are a couple easements that we've discussed in the briefs, and one is the dock easement, and the other is this pedestrian easement between the properties from the Sound to the Bay, from the Sound to the Gulf of Mexico. And the Hagelands are not contesting the easements that are written in the deed that they received. They're contesting these easements in the declaration documents.
But at the time they received their deed, that declaration was of record, right?
Yes, it was of record.
So how did that not take subject to it?
Because if you have an invalid, void easement, just having notice of it, whether it's actual or constructive notice, makes no difference. Because certainly you can be aware of an invalid easement, but it doesn't mean that it's enforceable.
Had the declaration been recorded first, would you have this argument?
If the declaration had been recorded first, then the deed would say subject to all easements of record, and that dock easement then would have been of record.
Does that mean that at best, if we were to determine that you should prevail in some manner, does that mean that it would go back for a determination as to whether there was some error either by the creator of the declaration or by the clerk's office in terms of the order of recordation?
But before I get to that point, I just wanted to point out that even if the declaration had been filed first, I mean, we would still have that issue of the fact that she attempted to create these easements when she owned all the properties at once.
You can do it if you're creating a subdivision.
A subdivision or a general development plan.
Yeah.
And there's a lot of issues of fact that we would suggest are in this record that preclude the court from finding that.
Well, but that's what my question was.
Yes.
If we found any merit in your argument, would it be a reversal simply because summary judgment was improperly entered, or are you suggesting that your client prevails outright?
We have made 2 requests for relief, alternative relief, and the one would be that you could find that the easement is void as a matter of law, and that you could reverse on that basis, and also enter summary judgment.
And it would be void as a matter of law, why? Because the declaration was recorded second, or are you saying they didn't comply with the law in order to create the subdivision that appears to be what she was trying to do?
Yeah, because she was creating easements on property she owned, and she didn't do it pursuant to this general development plan case law for a number of reasons. But alternatively, we would say that the court should reverse based on all of the issues of fact, and those have to do with whether she did create a general development plan. And for a number of reasons, we think her intent wasn't clear.
What's a little odd is the 41 minutes. You know, when a lawyer goes to the clerk's office to record something, more often than not, they will specifically be concerned about the order of them and hand them to the clerk in the order they want them recorded, or have a letter with instructions. And ordinarily, a sequential pile of documents to be recorded are minutes apart. 1 minute, 2 minutes, 3 minutes. 41 minutes is odd. Do we know anything about that? Is there anything on our record about why 41 minutes as opposed to 4 minutes, which would make more sense?
There's nothing in the record.
Okay.
There's no deposition of the clerk or of Sandra Epolite. There's no affidavit from her.
And there's also, if I recall from this record, no evidence of the use of these easements. In other words, that might make them prescriptive easements because they were used. We have none of that either, right?
Right. There's nothing in the record that was submitted to the court for summary judgment purposes having to do with how the easements were used.
Okay.
Also, you've mentioned this general development plan argument, and we would submit that the court shouldn't even consider that because it wasn't properly raised below. We've cited case law in our reply that holds that a trial court may not grant summary judgment on a ground that was not raised in the motion for summary judgment. Also, in the second amended complaint, this term general development plan is not used. The second count, that's the one we're concerned about, it talks about all the different forms of notice as being the basis for entry of a declaratory judgment. Again, not mentioned in the motion for summary judgment, that focuses on notice. And then finally, the court's order doesn't mention a general development plan. There was no finding that there was one. Of course, we have the Florida Rules of Civil Procedure, which say that the motion for summary judgment shall state with particularity the grounds upon which the motion is based. And the Hageland's counsel didn't respond to this argument because the argument hadn't been raised. So the trial court really didn't have an opportunity to deal with it. In addition to all the cases I've cited in the reply, one other case that is an easement case that I've cited in the reply is the Fior versus Hilliker case. And in that case, the court declined to consider the appellee's arguments that were not raised below. So I would urge the court to take the same path here. And with respect to all of the issues of fact, of course we have to consider that restrictive covenants are greatly disfavored by the courts, and they have to be strictly construed. There's a lot of ambiguities in the original declaration and in all of the subsequent declaration documents. Of course, the original declaration doesn't have legal descriptions attached, except for there's this Exhibit A, which happens to be a legal description of the Hagelands property, but there's no reference to an Exhibit A. There's also this reference to the master site plan as being attached, but it's not attached. And also, as I've mentioned before, Polite, she didn't actually subdivide the property. What we understand as being a subdivision is the division of land into 3 or more parcels from one parcel of land. That's not what happened here. There's also a definition of development in the Florida statutes, and under that definition, things that constitute development include carrying out a building activity or mining operations, the changing of the use or appearance of a structure of land, or dividing land into 3 or more parcels. Again, that didn't occur here. Also, the original declaration, it says that these easements are hereby created, meaning they're created now, immediately, when she owned all of the parcels all at once. They didn't say anything about when I sell a particular parcel, then the easements will spring into existence. And let's see, additional issues of fact. Of course, for some reason, Polite, she failed to include this dock easement in the deed to, it was first to the Davids, and then the Davids then sold the property to the Hagelands. We don't know why she didn't include that easement in the deed. She failed to reference the original declaration in the warranty deed to the Davids. Yes, she could have done that. And she also, as I mentioned, she failed to include any descriptions of these parcels in the original declaration, and we don't know why she didn't do that either. Just as we have a number of problems with the original declaration, there's additional problems with the subsequent amendments that she did. She did there's a supplemental amendment that we've called in our brief, and additionally a first amendment. And none of those rectified the problems that arose in the original declaration. A supplement to avoid easement doesn't render that old void easement valid. She would have had to recreate an easement in a proper format in order to have a valid easement. Also, the amended declaration, it violates the statute of frauds. She didn't have anyone, in addition to herself, sign that amended declaration. She thought she could do it, apparently, because she owned most lots at the time. However, if you look at the definition of owners in the original declaration, we would take the position that owners means people who own property. So at that time, there were the Davids. They were both owners. And then there was Miss Ebolite. She was an owner. So she was not a majority of the owners. Some of the case law that opposing counsel cites has a different language in the declaration documents. They talk about a majority of the owners of the lots, or that each lot gets 1 vote. In our case, the original declaration did not include such language. So she didn't have enough signatures. The First Amendment, it suffers from the same problems that I've mentioned before. Additionally, it doesn't reference the amended declaration, which purportedly had restated the entire original declaration. and it attaches a master site plan, but it omits the descriptions of the parcels that had previously been included with the amended declaration.
Ms. Weber, you're at your rebuttal time.
Okay, thank you.
May it please the court, my name is Jason Gaskill of Adams and Reese. I'm here on behalf of plaintiff U.S. Funding, who's the appellee in this case.
So then,
I was ready.
if you don't mind, Miss Hippolyte, how do you say her?
I'm not sure on the pronunciation.
Okay. Well, I don't want to mispronounce it, but she creates this deed, issues it to the Davids. 41 minutes later on the same day, this declaration goes of record. Therefore, at the time she conveyed to the Davids, there was no encumbrance on this property by virtue of an easement, assuming it could have been created, even though its effort to do so seemed to violate, the general development sort of requirements of doing this. But let's work with just this simple construct.
The recording issue itself.
Yeah,
Sure.
so the Davids have this property. The declaration which creates these easements purportedly follows it. So the Davids take it, not subject to the declaration, not subject to it. They then convey to the Hagelins, this is like real property 101, isn't it? I mean, I just
would
don't.
agree it is,
Yeah.
but I think as to the Davids, we're dealing with a slightly different issue. And here's why. On that initial declaration of covenants and easements, it says in the recitals, Ms. Hippolyte is the owner of 5 parcels, and then it goes to describe what they are, and there's an issue there that we think we've clarified. On that same day, a deed is conveyed for what we've identified as parcel A, which is one of the Gulf side parcels, Bayside, to the Davids. Now, under the recording statute in Florida, and I'm sorry it's not in the brief, but we have a race notice statute.
Yeah.
That affects essentially, recording is for third parties to provide constructive notice of things related to property, not to the actual parties to transactions. Now, a relevant case actually cited by opposing counsel is the Hensel versus Aurelio case. That was one of the unilateral deeds or easement cases, and they addressed the issue. In that case, Aurelio attempted to get an easement when he was selling property to Hensel. Hensel disagreed with that request, and it did not make it in the contract. So Aurelio did his own easement while he still owned both properties. They were neighboring properties. And then he recorded that in advance of delivering the deed to Hensel. Now, the court said 2 things. One, because it was a unilateral easement scenario under unity of title principles, that was an illegal or an improper easement and therefore not valid. But also secondarily held that even if it was valid, the recording of the declaration would not add any validity to it because parties to the transaction themselves are not affected by the recording. Recording's for people down the chain of title, not the people that are actually in the room during the transaction. What we know about, from the record, what we know about that transaction with the Davids is Ms. Hippolyte executed the declaration with a recital that she was the owner of all of the properties at the time of the execution. That same day, she executed a deed to the Davids. Those documents don't get recorded for 50 days. So I would assert the 41-minute difference is wholly irrelevant to this case because at that point, David's already took title. Ms. Hippolyte already subjected the properties to the declaration.
How do you say it's totally irrelevant to this case? I mean, to me, it's everything.
Well,
And the fact that they were all signed 50 days earlier on the same day, I mean, you have to go with her intent to record. It would appear that her intent in recording was that this David property was to be carved out of the declaration.
I would assert, Your Honor, her intent comes from the declaration itself that says, I am the owner of all these properties, and I subject them to these covenants, restrictions, and easements as set forth therein. And then on that same day when she deeds it out to the Davids, she hasn't changed that intent. Mm-hmm. That would be a defense that could be raised if they sought to void the declaration based on what the Davids knew if they didn't know about the declaration at the time. That's not evidence that's been presented as a defense by the Haglins in this case. Our case, Your Honor, is quite simply under count 2. We proceeded And the claimant says, Haglund's took this property with knowledge of these 3 documents. The documents are the Declaration of Covenants and Easements, and in there it has a number of easements. There was an issue raised about the fact that the recital identifies parcels A through D.
Do we know in our record what their title policy looked like? Did the title policy reference these declarations, or did it insure over the declarations? Do we know that?
I can't tell you what, I can't say what the record has. The record doesn't have it.
I only want to know what the record, I don't want to know anything outside of the record.
Yes.
Okay. Can I shift gears on you a little bit?
Yes.
I know you're dying to talk to me about some
No,
things, but I got a few
please do.
questions I just want to get off my mind, and
Certainly.
you can talk all you want, okay? Let's assume your easement's valid.
Okay.
I'm working with the fact that it's valid. And it does address, it appears to me, the use of a dock for loading and unloading. Am I correct? And that's all it talks about. And this case is all about using this dock, right? I mean, that seems to be the big thing. Everybody wants to use this dock.
I think it's fair to say that that's the big gorilla of the case.
Doesn't
is
talk
these
about
docks.
that you can fish off the dock, you can lounge on the dock, you can bring your boat up to the dock. Doesn't talk about any of that. It just talks about loading and unloading. Have I misunderstood that?
It's slightly more broad. I could
Okay.
read it. It's actually section 2.2, and it provides a perpetual right for the owners to use the dock for purposes of installing, using, operating, maintaining, repairing, replacing, relocating, and removing all the walkways, boardwalks, and docks located here and after in the easement area. And then it was subsequently amended in the First Amendment, or the amendment and supplemental, that provided rights for vehicular access for purposes of constructing on the other parcels. This is just for orientation.
But there's no
purposes.
recreational.
No,
use.
there's no additional use
Okay,
rights.
there's no record, okay. The other thing that, and again, I'm just looking at the diagram included in the brief.
Yes, Your Honor.
It doesn't appear that the easement touches the dock.
The easement, there's more than one easement in the document itself. There is the pedestrian easement, and forgive us, that's just rough artwork
Okay.
from my office. It's not intended to be an exact
Okay.
showing of where they are.
Because
And
it
then
looks like there's a gap between where the easement would be and be getting on the dock. Is that not an issue? That's not a big deal?
It's not, because
Okay.
I think the rest of the easement language gives you the right to get to the dock for
Okay.
that limited purpose.
Okay, okay.
And that's both in the original as well as the
So
supplemental.
it's like an easement in gross between wherever the easement appears to stop and the dock begins. You have a right to cross that area and get there.
Right.
Okay, all right, okay. That's good. Go ahead.
Now, Your Honor, as I mentioned, we brought this case, there's 5 different counts, because we have both the Haglund property, then below that, the Murdoch's own another parcel, or McCullough's own another parcel. The bank owns both the Gulf side parcels. Haglund's and McCullough's own the bay side where the 2 docks are, as referenced in the image that we put in our brief. In count 2, we sought a declaration of the right to use the dock on the Haglund property. And in that it said, you have notice of those 3 documents. That's the basis of our claim. Now, the material facts to that are, these documents exist. Did you have notice of them? If you have notice of them. Under the Kerma case, the second DCA case from, I want to say 1978, Your Honor, a buyer takes subject to any documents or rights that he has knowledge of. And in this case, we have clear constructive knowledge. The Haglunds did not buy this property until 6 years after the last of the declaration documents was recorded.
Yeah, but isn't that case all just about record notice? Or otherwise have actual knowledge? In other words, you got imputed knowledge of things that are of record, but you got to have actual knowledge of other things that might affect it. And that's what that case is really all about. It appears you're trying to use that case to leapfrog your recording gap of 41 minutes. And I don't think that case stands for that.
That's not our intent, Your Honor.
Okay.
The intent of that case, as well as the later Romack case or Rodak case, also second DCA case, is that whatever you have notice of, you take subject to. And actually in the Kerma case, it was a sewer easement issue, and the developer didn't handle the documentation correctly, but everybody was aware of the sewer easement as well as his intent.
But see, the Haglunds took notice of the fact that the deed they got from the Davids was not encumbered by the declaration because the Davids got their deed from Miss Ippolite before she recorded the declarations. That's what they had notice of.
I think that's that would require a jump from the recording statute. What they got is the declaration that states that she owned all 5 when she did it. And then a deed to the Davids, a supplemental declaration that says she no longer owned all 5, she only owned 4 because she had transferred 1 to the Davids. That's also of record. And then a second supplement.
Why does she have to go to any of that trouble when she has a deed and the deed precedes the declaration? Why does she have to go looking at the First Amendment and all the other documents? She just says, I got a deed from the Davids that was recorded at such and such a date and time. Nobody's told me that this is encumbered by any declaration because the public records don't reflect it. Why does she have to go through any of the hoops that you're suggesting tell her that, oh yeah, you really are encumbered?
I think the supplemental, the 2 supplemental documents, actually one's a supplemental and one's a First Amendment. The First Amendment actually addresses the missing master site plan and says that it was an error and therefore a corrective document and goes backward. And as well as the supplemental. In both those documents, it says of record what happened with the transaction as far as her no longer being an owner of the property of the Davidson parcel. And those would be in the title review.
Yeah, I guess my point is, what puts subsequent buyers on notice that they have any responsibility to look at later recorded documents?
I think in this case, we don't have to go there only because we have, and what I've asserted, we have constructive notice because it is of record, but in addition to that, we have admissions from the Haglunds that they had actual notice of these documents. So we don't have the issue of did they have a duty to go find them.
They admit they know of the documents. Do they admit, I think they don't admit that it's binding on their deed.
Well, unfortunately, we wouldn't be here if they did admit that.
Right.
But they do admit the knowledge of the documents. Now, under notice requirements, we're required to show the documents exist, they have knowledge of them, and therefore they're bound by them. We've shown that. Their defense is that that is not binding on them, and their primary defense is under this unity of title issue, which I can get into in just a moment. But what you're getting into is the recording, the order of recording. For them to assert it as a defense, they would have to show that it wasn't binding on the Davids, despite the fact that this was a single-day transaction.
Do they have to show it wasn't binding on the Davids, or do you have to show it was binding on the Davids?
I think that...
And if you show that it was binding on the Davids, what in the public records tells a subsequent purchaser, don't rely on the deed. You have to look at some other documents and maybe some settlement agreement or something where the Davids acknowledge outside of the public records that it's binding on them.
Well, and I think in this case, we wouldn't have that issue because of the supplemental declarations that postdate the deeds. They would show up after the deed. They would be in that chain of title.
Did the Davids sign those?
No, they did not.
So I'm going to go back to the very first question I asked.
Yes.
What tells anybody down the chain of title that don't rely on the deed, you need to look at some later recorded documents to which your predecessor in title is not a party?
I think there's a duty to inquire once you get a document that's in your chain of title to determine its validity.
But it's not in the chain of title.
And I think, Your Honor, because the supplemental documents necessarily reference and in fact attach the property, they would be in the chain of
So you're saying
title.
subsequent purchasers have to go through the public records to later recorded documents to see if somehow those later recorded documents are going to relate back to a deed that doesn't say it's bound by the later recorded documents.
I believe if they have actual notice of it, they are in a duty to inquire to find out.
But the actual notice would be that I know the Davids are bound. I know that their deed doesn't represent what it says it represents. And so what evidence is there of that?
I don't mean to suggest that that's what the actual notice is. The actual notice is of the documents themselves. And
Well, the world at large is on notice of those documents. The issue isn't whether the world at large is on notice. The issue is whether the world at large is on notice that this particular deed that precedes any of those documents is bound by those later recorded documents.
And the deed doesn't even reference the documents, doesn't say subject to, which is really hard to understand.
I understand it has the standard subject to.
Yeah, I mean,
easements,
if that was the intent, that it be burdened by an after filing, it would definitely say that. And the fact that it doesn't say that really strongly makes a case it wasn't intended to be burdened by it.
And I think as far as what the intent is, I'd have to look at the actual document itself. And what did Ms. Applite say in her declaration of covenants and easements? That's the statement of intent we have. We have no other evidence of intent, both for or against. We have what she said in that document as well as the subsequent amendments.
Most title agents would have insured over this. They would have said, they would have looked at the chain of title and said, it's not encumbered. I'll strike it, I'll take it off the, off the commitment. I'll strike through it. Most of them would. As a matter of fact, I'm not sure any of them wouldn't.
I would actually expect that this would stay as an exception to every single title policy. In my primary area of practice is title coverage, and I would be shocked if it didn't remain as an exception, only because clearly they were on notice. This isn't a constructive notice issue in that scenario of would I find it, therefore, if it's outside the chain, could I find it? Because that's where you get to constructive notice. If I went and did a title search, would I find this document? We know they found it. They admitted they found it. They knew all about it.
You would find it, but you would find that it's out of the chain of title.
Out of recording order, but the dates of the actual documents are the same. So it doesn't suggest they're out of the chain of title. They are both dated the same day. There is no suggestion in any of the documents.
But the deed doesn't reference it. And if it was intended to be burdened, I can't imagine why that deed wouldn't reference it.
And I unfortunately can't answer that question for you. So, moving past the notice issue and what we believe is the material factors they were on notice in what those documents provide, and they're bound by them. We believe the defenses asserted are the burden of the Haglunds to support by evidence. That would include whether the Davids took free and clear of the declaration because they didn't know about it based on the recording order of the documents, because that's the only relevance of the recording order of the documents from the standpoint of what the notice would be there. The other issue primarily raised, or the number one defense, Your Honor, what we have here is we know the Haglunds took with notice of the documents. And subsequently, they're trying to cut off the rights of what are provided in those documents. In support of that, they rely heavily on a couple cases that deal with unilateral easements. Specifically, the case I just mentioned, Hensley versus Aurelio, as well as One Harbor Financial. And Your Honor, we've cited in our briefs cases that stand for the proposition that you can, as a unified or a solitary owner, subject your property to a plan, a restrictive covenant, easements, whatever you want to put on that property, and it is valid once that first severance takes place. And that goes all the way back to the Warrendorf case, v. Moore, by the Supreme Court of Florida in 1957. Now, in that case, it was actually a plat, but what the court said was these attempted restrictions and easements they're of no effect during unity of title, but upon that first severance, they become valid. Now, take that down to 1997 when the Fifth Circuit dealt with the Parlato case versus Secret Oaks Association. We have a developer dealing with a subdivision which included a recorded easement in favor of multiple lots for pedestrian access to a river and a dock. And it stated both existing or in the future to be built. I'm paraphrasing. In that case, the Parlatos bought the property and then did similar to the Haglunds here, sought to avoid the obligations of that easement. And the court stated in that, finding that it was a valid easement, said the easement does not, or expressly provides for the building of a future dock, so therefore the Parlatos cannot stop that. Now, in the case of, also cited in our brief, Esmond versus Erickson, we have a developer who owned all properties that were dock properties and dwelling properties, and he recorded a declaration of restrictive covenants that had easements. So basically the exact type of document we're talking about here. In that case, the court expressly found a valid easement created at the time a unity of title, and therefore they controlled whether or not the dwelling lots and the dock lots were tied together. Now, the cases cited by the Haglunds, the unilateral easement cases, in One Harbor Financial, we have a document called an easement agreement, which is prepared by an owner that owned two abutting properties. That easement agreement provided that one of his properties would benefit from parking spaces on the other property because he was attempting to avoid zoning regulations and parking restrictions. In that case, which is in 2004, the Fifth Circuit said there's no other reported case in Florida that specifically addressed the issue where one property or one owner owns adjoining parcels and creates an easement in favor of one over the other. Now, we know in Warrendorf that 50 years ago, the Supreme Court said you can have mutual restrictions and they spring into existence upon severance. And so I would assert that that's, to the extent they use that phraseology in that case, they were dealing with what they believed was a difference, a unilateral easement versus a development plan.
You're at the end of your time, but I want to ask one question, somewhat of a hypothetical. If the Davids had, at some point in time, been confronted with this entire situation as far as the easements and docks, and if they said, wait a second, we didn't know about any of this, all we know is we got a deed free and clear. The issue that would have been tried would have been, did they know through course of dealings with the seller that this in fact was what was intended to happen? And if a trial court would have believed the Davids that they didn't know, they had no reason to know, nobody told them anything about it, that would have been the end of it, your client would have lost out. Is that a fair understanding of how this would have worked?
Just make sure I paraphrase it. So in this scenario, the Davids
never
say, we didn't know anything about this declaration of covenants.
She didn't tell us that she was trying to set this up. She didn't tell us she was trying to set up easements. She didn't really tell us she was going to subdivide, but obviously we got a piece of the property, so we knew she was selling us a piece of it. But we didn't know about any of this other stuff that she was intending to do. And
Yes.
the trial court believes them.
Yes, and I'll add the additional fact that if the declaration was recorded in advance, they kept it secret from her, arguably even then.
Then it's on. Well, it may still help them, but at least on the record, they're now on notice that their deed following the title search should have picked it up.
Correct.
If it was already in the records. But using my hypothetical that everything happened exactly the same, except the Davids never sell, and at the time that the seller is now trying to put in pathways or whatever, they're saying, hey, what are you doing to my property? If the court believed that the Davids never knew anything about her ultimate intent to develop, your client basically loses because she messed up the recording. Is that a fair?
I don't think she loses because of the recording, or they lose because of the recording.
Well,
they would lose
the lack of recording and the lack of actual notice to the Davids.
And the reason why I say this, because of the 50 days, that's 50-day gap, I
Which
assert
is
doesn't affect
inexplicable.
this. No, I just assert that doesn't affect this only because the declaration and the deed are on one day, based on the face of them and their execution. If the declaration was executed and the Davids were not told about it, and separately then the deed comes out to the Davids, regardless of recording at that point, unless it was recorded and we had to rely on constructive notice, you're correct. Anyway.
Okay, thank you. Ms. Weber?
Can I ask you a quick question before you get into what you're going to tell us? One of the positions you've taken is the trial court misconstrued the easement terms. You want to just sort of walk me through that a little bit?
Sure. So the trial court said that U.S. funding has the right to access the Hageland's dock, but the original declaration specifies that only one of the lots that later became owned by U.S. funding would have access to the Hageland's dock. So the trial court's order doesn't specify which lot would have access. It may not matter now if they're both owned by U.S. funding, but it would matter if they sell the property to different owners. And additionally, there's this issue about, the language that the trial court used. I believe she said that U.S. funding has the right to access and use the dock, and we've taken the position that U.S. funding, if they prevail on all their other arguments, they wouldn't have the right to use the dock for recreational purposes and fishing and watching fireworks and all of those things, because it was, that dock easement was just for the purpose of kind of the loading and unloading. And the section that they cite to that uses the word use of the dock, we think it's really more intended to talk about the maintenance of the dock, just using it in order to be able to fix something on it, but not to linger on it. So those were some of the issues that we had with the
Okay.
order as phrased.
I don't recall this. At the time your client got the deed, were there was it an open and obvious situation that, other people are accessing this property? Does the record tell us that?
The record does not discuss what
So the open and obvious
Hegel's knew.
nature or lack of open and obvious nature is not addressed?
No, that's not at issue. In this appeal, it's not part of the record. Mhm. In responding to their arguments, I would argue that Hippolyte's intent is ambiguous. Her intent certainly could have been to carve out the David parcel from the other easements that she was attempting to create. And I would refer to the court to the case that I've cited in page 10 of my reply, the Kukler case out of Indiana. It just has some interesting language, and it says that the deed or the plat is the final word as to all agreements. And the court noted that where here a party unilaterally sets restrictions on his property and then omits the restrictions in the actual conveying instruments, we are left wondering as to what the conveyor's intent was. And I think that's what we're left questioning here. Why did she omit the dock easement from the deed? Why didn't she record the original declaration first? We do take the position that there is this gap between the dock and the pedestrian easement, and we would not agree that that can be resolved easily, certainly not in this appeal based on the evidence in the record. So those two don't connect. For the notice issue, again, we think it is a red herring. It doesn't matter that the Hagelins had notice of the documents because they thought that they were taking the property free and clear of any encumbrances because they believed that the Davids had taken it free and clear.
And the deed from the Davids to the Hagelins also did not reference the declaration. Is that correct?
Right.
Okay.
Mm-hmm.
Evidencing that they really didn't think they were encumbered either.
That's right.
Okay.
Yes. And we think there is nothing wrong with relying on the black letter easement law cases that we have, Hensel versus Aurelio and the others. The cases that they have cited, Parlato and Esbin, we think that they're distinguishable for the reasons that we assert in page 7 of our reply brief.
That takes us to the end of the time, Ms. Weber. Thank you.
Thank you very much.
Very interesting case, well argued, both of you.
The final case on the oral argument